Alright, Chapter 12, Examination Applications. Examination Application Notice of Projection, Re-examination Time of the Prosecuting Application, Appeal of the Patent Trial, Appeal Board, Appeal of the Transitional Appeal of the Board of Patent Appeals and Interferences, Pre-America Inventors Act, Appeal of the Board of Patent Appeals and Interferences, Deviation Proceedings, Pre-America Invention Act, Interferences. Alright, Title 35 U.S. Code 131, Examination Application. The director shall call for the examination made for the application alleged for the new invention. If not, the examination preview of the application is entitled with the patent or the law of the director shall issue the patent thereof. Title 35 U.S. Code 132, the notice of the rejection and re-examination for the examination aimed at the claim of the patent rejected for the application required with the made with the director that shall know for the application thereof the tape of the reason for the rejection and objection of the requirement that together with the information rather than may use the role in judging of the priority continuing prosecution of this application after receiving the certificate notice application persistent and claim of the patent with or without the amendment the application shall be re-examined. No amendment shall be into the new matter of the disclosure of the invention. Director shall prescribe regulation provide for the continuing explanation of the application of the patents for the request for the application for the director for the manuscript with the probative fee for the continuing examination shall provide 50% reduction in such fee for the small entity with the qualified with the reduced fees under section 41 and H1. Title 35 U.S. Standard Code 133, time of the prosecuting, application upon failure, application prosecuted the application with 6 months after any of thereof without notice to have been given the mail the application with such short time, no less than 35 fixed director and such party of the application shall be regarded as abandoned by the parties. Title 35 U.S. Standard Code 134 of the patent trail and the appeal board patent application of the applicant with the patent who claimed it has been twice rejected may appeal for the decision primary examiner patent trail. Appeal board having once paid fees for such appeal. The patent owner in re-examination may appeal final rejection of any claim of the primary examiner of the patent trial. Appeal board having once paid the fee of such an appeal. Title 35 U.S. Standard Code 134, Appeal of the Board of Appeals and Interferences Patent Owned by Application of the applicant of the who claimed with the twice rejected the applicant with the decision primary examiner of the Board of Patent and Appeals and Interferences. If one's paid the fees for such appeal, the patent owner in re-examination may pay the final rejection of any claim by primary examiner, Board of Patent and Appeal for the interferences have the ones paid for such a fee. Or 134 Pre-America Investment Act appeal for the board patent and appeals and interference with the patent application of the applicant with the patent who claimed to have the twice rejected that ban appeal for the decision primary examiner board with the patent and appeals and interferences having once paid the fee for such fee. Such appeal of the patent owner re-examination proceed with the may appeal for the final rejection and claim of the primary examiner of the board of patent appeals and interferences have the ones paid the fee for such fee appeal. Third party requester and inter parties proceeding may appeal for the board of patent and appeal for the interference with the final decision pre-examiner of the favorable of the patent any original proposed amended new claim of the patent having once paid for the fee for such appeal. All 35 U.S. Standard Code derivation proceeding. The Institute for the proceeding in general the application of the patent made with the favor of the petitioner for the invention. The Institute derivation proceeding with the office of the petition set forth the particular basis finding the individual name of the earlier application of the inventor, joint inventor derived of the invention of the individual name of the petitioner, application of the inventor, joint inventor without the authorization with the early application claiming such invention was filed when the director determines the petition filed within subsection demonstrated with the name of the institute with the derivation proceeding in a meeting with the director may institute with the derivation proceeding. The time for filing a petition on subsection respect the invention of the same or substantial same invention claim under the patent issued for the early application contained in the early application deemed published in section 122B may not be filed unless as petition filing under the during one year period dating with the patent containing such claim with the granted earlier application containing such claim with the published whichever is earlier application for the purposes of section application shall not deem the earlier application for the respect of the invention relative to the other application unless the claim of the invention was or could have then made with the same application and have the effective filing date earlier with the effective filing date any claim of the invention was or could have been made in such other application. No appeal with the determination director with the institute with the deviation proceeding with the paragraph 1 shall finally not be appealable. Alright, B, the determining patent by trial and appeal board with the derivation proceedings institute with the subsection A with the patent trial with appeal board determination with the inventor, namely the earlier application derived claim an invention with the inventor named in the petition or application without authorization. Earlier application claiming such invention was filed with the appropriate circumstance with the Patent Trial Appeal Board may correct with the name of the inventor by any application of the patent issue. Director prescribed the regulations set forth stating that dealt with the derivation proceeding, including the requiring parties to provide sufficient evidence to prove, rebut, claim, and a derivation. Deferral in a decision patent trial with the appeal board may defer at the action of the petition with the derivation proceeding the expiration 3-month period beginning with the date of the director issued the patent, including the claim and invention of the subject of the petition patent trial. Appeal board also may defer to the action petition, the derivation, and or stay with the proceeding after the instant of the termination proceeding under chapter 30, 31, 32 with involved with the patent and earlier application. Effective final decision patent trial. The appeal board with the diverse and claim the application of the patent, which shall constitute the final rule for use over the other. Or for those claiming the final decision patent trial, the appeal board averse to the claims and patent of the appeal for the other review of the decision has been taken, can be taken or had, and constitute cancellation claim. The notice of such cancellation, or the copies of the patent distributed after such cancellation. Or a settlement. Parties proceed with the instance within subsection A with the terminate proceedings over the filing with a written statement of reflecting the agreement over the party for the correct of the inventor claiming the invention of the dispute in the life of the patent trial. The appeal board filing with agreement to being consistent with the evidence of the record, if any, shall take of the action consistent with the agreement with the written settlement with the understanding of the parties shall be filed with the director if the request of part of the proceeding or agreement or understanding shall be deteriorated with the business confidential information shall be kept separate with the file of the involved. Patents of the application should be made available only with the government agency written copy of any of the person showing good copy of the attribution. The party for the proceeding instituted under subsection A of the May of the time session for the director of regulation determine the context of any of the aspect thereof of the arbitration. Arbitration shall be governed with a provision of Title 9 extent when the subject of the title is not inconsistent with the section of the party shall be notice of the arbitration and award with the director such award shall be between the party of the arbitration and dispositive of the issue with which it relate with the arbitration and award shall be unenforceable until the covenant notice is given. Nothing in subsection preclude with the director of determining patentability over the claim and inventions involved with the proceeding. A. The claim of the invention have an effect with the filing date with the defined section 101 of the curve before March 16, 2013. B. A specific reference under section 120, 121, 365C to a patent application that contains at any time such claim. Title 35, U.S. Standard Code 135, Pre-America Inventors Act, interferences with the application that is made with the patent within which the opinion of the director would interfere with the pending application with any unexpired patent interference made with it to be declared with the director shall give the notice such declaration application or applicant with the patentee as the case be with the Board of Patent Appeals. The interference should determine the question priority of the inventions may determine the question patentability final decision versus and claim in the application constitute the final refusal by Patent Trademark Office of claims involved, and the director may issue the patent into the application or judge with the prior final judgment adverse patentee, the which no appeal with the other review that has been taken when the shall counsel with the cancellation claim and involved with the patent. No such cancellation drove with the copies of the patent distributed in such cancellation of the Patent Trademark Office for the B1 of the claim, which is the same or same of the substantial same subject matter of the claim, and the issue of the patent may not be made with the application such claim that made with the prior to 1 year of the date of the patent was granted with the 2 application claim which of the same of the substantially same subject matter of the claim applicant published under subsection 122B with the made with the application filed with the application is published to author only with the claim that made with the before 1 year of the date of the application is published. See any agreement. Any agreement or understanding between the parties of the interference, including collateral agreements, referred to the area with connection with the contemplation of the termination, interference with the writing of the truth of the copy with the area of the patent trademark offer before the termination, interference as between said part of the agreement is understanding with the party filing, same with the request copy to show with the capital step forth of the filing, interference made available to the government agency, written request for the name of the person showing good cause failure to file with a copy of such agreement understanding the render of the permanently unenforceable such agreement and understanding that any of the patent such parties that involved with the interference patently subsequently issued with the application of such parties that involved with the director may, however, on showing good cause of the failure within the time of the prescribed of the permitting filing with agreement understanding during a 6-month period subsequent to the termination interference as between the parties with agreements understanding with the director shall give the notice to the parties for the attorney's record of the reasonable time prior to the set of the termination following requirements for the tax and director give it as such and notice at a later time respectively. Right of file such of the agreement, understanding with a 6-month period on the showing with a good cause of the parties being filed with the agreement, and understanding within under 60 days of the receipt of such notice. A. The claim of the invention has been effective the filing date, section 101, occurred for the March 16, 2013, specific reference of the 121, 120, or 365C with the patent application contains contained at any time such claim. Chapter 13, review of the patent trademark office decision.